Eminent domain is a legal tool some governments use to spur development on underutilized properties.
In tonight's Legal Lens, Fox 2's Jeff Bernthal asked Brown and Crouppen attorney Andrea McNairy how eminent domain can be used and what the law says about compensation for property owners.
Andrea, we hear the term used a lot, but I guess what exactly is eminent domain and when can it be used?
Eminent domain is the government's power to take private property for public use. So the government includes other entities such as utility companies, railroads, redevelopment corporations. They also get to use this power on occasion. The other big part of this and the big inquiry is for public use. So the Supreme Court has interpreted public use to mean any valid public purpose, which can use building roads, airports, utility lines, distribution centers, parks, as well as takings to foster economic development.
And that's the use we hear a lot about, that economic development here locally. I guess, what about compensation for the property owner in a situation like that? How does that work, or how is that determined?
So the Constitution guarantees just compensation. Under Missouri law, that means the fair market value of the property. So what a willing buyer would pay on the open market at that time. If only a portion of property is taken, then the owner is entitled to not only a fair market of the portion taken, but also any diminishment of the rest of his property. In Missouri, Missouri law provides that if a house is taken for eminent domain, the owner is entitled to 125% of the market value. And if that house has been owned by that family for 50 years or more, they're entitled to 150% of fair market value. So you can see that the argument is often going to come down to what actually is fair market value at that time.
Sounds good. And I guess if a property owner wants to, fight this, do they have any recourse?
They do. So 30 days before a petition is filed with the court for a takings under eminent domain, there must be a written notice to the property owner saying what the fair compensation will be offered. The homeowner has a chance then to negotiate from that price and see if an agreement can be reached. If not, then the case will go to the court, and the court can first determine if it's a public use, and two, if the amount offered is a fair market value. And then finally, if the court does a taking or does not, both sides have the ability to avail themselves of an appeal. Usually those appeals are taken strictly for the purpose of determining whether or not something is a public use.
Some great information to know. Andrea McNairy with Brown and Crouppen. As always, we appreciate your time. Thank you.
You're welcome.
Jeff Bernthal, Fox 2 News.
And you can catch the Legal Lens on Fox 2 every Wednesday at 6 p.m.